Calling to order this hearing. This is a hearing or public roundtable of the Committee of the Whole of the Council of the District of Columbia. I am Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole. Today is Thursday, February 4th, 2021. The time is 10:11 in the morning. We're conducting this hearing virtually on the Zoom video conference platform, as well as the council's website, www.dccouncil.us, TV Council Channel 13, the Office of Cable Television website, entertainment.dc.gov, and my own website, www.chairmanmendelson.com/live. The subject of this morning's hearing or roundtable is a consideration of PR24-21 entitled the Board of Zoning Adjustment Carl Blake Confirmation Resolution 2020. This legislation was originally introduced by the mayor on or about November 23rd last year. Under our rules, it was held over as a resolution and is currently PR24-21. The stated purpose of PR24-21 is to confirm the appointment of Mr. Carl Blake to the Board of Zoning Adjustment for a term to end on September 30th, 2022. Mr. Blake would replace Leslie White, one of 3 mayoral appointees on the 5-member board. The Board of Zoning Adjustment is an independent quasi-judicial body with the ability to grant relief from the strict application of the district zoning regulations in the form of variances, to grant special exceptions where authorized under the zoning regulations, and to hear appeals from actions taken by the zoning administrator of the Department of Consumer and Regulatory Affairs. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on February 18th, 2021. According to the Secretary's memorandum circulating this legislation is deemed disapproved on Thursday, March 11th, 2021, unless the council takes action. So we have 2 witnesses. I'll call the first, Mark Eckenweiler, who's an ANC commissioner with ANC 6C04. And Commissioner, when we're done listening to you, then I will call the applicant and ask for his testimony. So it's good to see you this morning, Commissioner, and Happy New Year.
Good morning to you, Mr. Chairman. Can you hear me okay?
Yes.
Very good. Thank you, Mr. Chairman and members of the committee. As you well know, BZA plays a crucial role in upholding the district's land rules in deciding, among other things, whether or not to grant special exceptions and variances. When those decisions are made right and in a manner that is consistent with the regulations, what happens is not only are individual properties improved, but also the areas around them. Conversely, when bad decisions issue from the BZA, those can both stifle needed growth and impose substantial hardships on nearby properties and neighborhoods. What's surprising is that the local law establishing the BZA imposes only the most minimum requirements for appointment. As you know, the 3 mayoral appointees need only demonstrate residency in the district for the previous 3 years, with one of them required to be a homeowner. When we look by contrast at the rules and statutes that govern HPRB, at a minimum, a majority of the members have to be professionals qualified in, quoting here, history, prehistoric and historic archaeology, architectural history, architecture. I won't go through the whole list, but there's a list of very specialized disciplines that must make up the bulk of the members of HPRB. And when we go deeper into the regulations, those require even more stringent, they impose even more stringent criteria, mandating that all HPRB members have demonstrated competence, interest, or knowledge of or in historic preservation. I'm here before you this morning to suggest that that disparity really makes no sense in practice. The tasks that are faced by the members of the BZA are, in my view, far more complex than those that HPRB confronts. They've got over 1,000 pages of zoning regulations to try and absorb and apply in practice. That's a profoundly demanding task. It involves scores and scores of defined terms, a lot of different zone-specific rules, and that requires a lot of informed judgment about not just legal, but also architectural and aesthetic questions. And as I think you probably know, I'm speaking here from personal experience. For the last 10 years, I've chaired ANC 6C Zoning Committee. In that capacity, I've testified at dozens and dozens of BZA hearings. On behalf of the ANC, I filed 5 different BZA appeals. I've observed countless other hearings, and even though I am a practicing attorney, I have 30 years of experience interpreting statutes and regulations. There are times when I myself find it a little bit of a challenge to understand parts of the zoning regs. And as we know, those regs remain a moving target. Every month, the Zoning Commission tries to tweak them to fill gaps, correct conflicts, and so on. And my point here this morning is this, that BZA members should bring substantial experience to this position because the job demands it. And as a result, the council should look closely to see whether or not nominees have the necessary qualifications. I would suggest that a record of accomplishment in urban land use planning, architecture, or law, or at the very least, some demonstrated interest in district zoning issues should be a de facto prerequisite, even if not required by statute. Even participation in zoning matters via a local neighborhood association, a civic group, maybe an ANC zoning committee would be helpful. And I think both to prepare someone for service on BZA, but also in affirming that in coming to this nomination, they have genuine enthusiasm for the subject matter. And I say that partly because I've found BZA increasingly disappointing in recent years, and much greater professionalism is needed in my view. We have one appeal outstanding right now. They voted over 2 years ago and there's still no decision on that. And I see my time is up, Mr. Chairman, if I can keep going.
If there was a long list of witnesses behind you, I would say we have to move along, but you can continue.
Thank you. It won't take much longer. I appreciate it. So as I was saying, we have one appeal. BZA voted on it over 2 years ago. They still have not issued a written decision. And frankly, I think part of it must be that OAG is grappling with how to reconcile that vote with the regs. I think it was a fully meritorious appeal, and I'll just leave it at that. I think BZA needs greater professionalism. We see the members of BZA struggling constantly with issues that I think are not that difficult. So coming to the present nomination, I've reviewed Mr. Blake's materials, and I see very clear evidence of a successful career in finance and property ownership. I'm not seeing here anything that suggests the kinds of skills and experience that are, in my view, essential to serving on BZA. Now, I don't know Mr. Blake. I don't know anything about him other than what's in that submission package. And it may well be that he has the qualifications and the temperament to serve effectively on BZA. My request to you is simply that you inquire closely to determine that, because the BZA does play this profoundly important role. As you yourself said, this is a quasi-judicial body. Its decisions have lasting impacts on residents across the district. I'll conclude my testimony, and I'm happy to answer any questions, Mr. Chairman.
Thank you, Commissioner. I'd like you to elaborate a little bit more on the appeals that you have filed. And when you said appeals, these would be appeals from the decision of the zoning administrator?
That's correct, Mr. Chairman.
Not appeals of BZA case decisions?
No, there wouldn't be anywhere for us to appeal because, as you know, ANCs can't, initiate actions in the courts.
Correct, but an individual commissioner can.
Yes, so the answer is no. Nothing in before the district courts. These are appeals of zoning administrator determinations. So the one I adverted to earlier, it's BZA 19550. The board voted on that in December 2018. So we're past 25 months of waiting for a written decision on that.
And sustain the decision of the zoning administrator.
Sustain the decision of the zoning administrator. There were 4 separate grounds for appeal. I'm simply at a loss to understand the logic behind the board's denial.
Has the board overruled the zoning administrator in your experience?
Not in the cases that I filed. They have done that at times. We've had other appeals where DCRA, and I don't want to spend this hearing obviously talking about DCRA a lot. DCRA has in a number of cases simply withdrawn. They revoked the permit because they can see what's coming, and they don't want to have to try and defend the indefensible before the board. So in many cases, it has not gone to an adverse decision against DCRA. They just pull the plug on the permit.
Yeah, and we have a performance hearing coming up on DCRA. I don't know.
We discussed that last night at our zoning committee, and we'll be back in front of you in the coming weeks.
Okay, do you want to say a little bit more about 19550? What were I'm not looking for a 10-minute discussion on it, but what were what I'm looking for is to highlight where the zoning administrator clearly appeared wrong or in error, and the BZA disregarded that. So
one of the grounds, I won't go through all 4 grounds, but one of the grounds was there's a rule for the RF zones, so the row house residential zones, that protects so-called rooftop architectural elements. So that includes things like turrets, dormers, and in this particular case, a cornice. So you can't simply rip off a cornice from a row house, and this applies obviously not just within the historic districts. This is a zoning reg across all the RF zones. This applicant had obtained a permit to completely rebuild the front facade, which would have included removal of the cornice. One of our grounds was that this violated the particular provision of the zoning regs, E206. And on cross-examination, I even elicited from the expert witness of the applicant that there was a cornice on the front of this building. So we had that in the record, not just from me, but from the applicant's own expert. And yet that ground was denied as well.
And was this a variance?
No, there was no variance or special exception. The point is the permit had already been granted.
Yeah, yes.
There were a number of things that were problematic about it. And frankly, the applicant went through multiple rounds of revisions of this permit in an attempt to avoid, the allegations in our appeal. But as I say, there were still parts that were problematic, and BZA chose to disregard those anyway, but has still not issued a written decision. And to come back here really to the purpose of this hearing, or at least the purpose of my testimony here, part of the problem with this delay is that the neighbor, there's an aggrieved neighbor, very unhappy about this project, and I think with good reason. That neighbor, if he wanted to take an appeal to the courts, still can't do it. There's no written decision from which he can take an appeal. So this project is substantially complete at this thing. The thing's already built. And because of BZA's delay in issuing an order, there is literally nothing that neighbor can do about it.
Yeah. I don't think I have any other questions for you. Let me think for a second. I don't have any other questions for you, Commissioner. Thank you, though, for your testimony.
Thank you.
It's helpful. So then we will turn to the nominee, Carl Blake, if he could appear. Good morning.
Morning.
Do you want to proceed? I have your statement, then I'll have some questions for you.
Thank you. Good morning, Mr. Chairman and members of the committee. My name is Carl Blake, and I'd like to thank you for providing me this opportunity to appear before you today. I'd also like to express my gratitude to Mayor Bowser for nominating me to the Board of Zoning Adjustments. I'm honored to be considered to serve on a board that's so vital to the character and development of our city. I was raised in Newark, New Jersey. I obtained an undergraduate degree in economics from Bowdoin College and a master's degree from the Darden School of Business at the University of Virginia. I was a CFA charter holder between 1992 and 2009. I accepted the nomination to serve on this board because it provides an excellent opportunity to use my skills and training to benefit and serve our community. I worked in the financial services sector for more than 25 years, serving in a variety of roles with increasing levels of responsibility for major investment and commercial banking institutions. As a securities analyst, I provided in-depth fundamental analysis to institutional investors such as mutual funds and insurance companies. Over the years, I developed subject matter expertise in several industries, including telecommunications, oil and gas, and financial services. As part of my work, I analyzed complex capital structures, performed detailed examination of covenants and corporate bond indentures, deciphered diffuse regulatory frameworks, and parsed an assortment of multi-layered business models. This work was often done under tight time frames and in highly pressurized situations where speed and accuracy were critically important. In conducting my work as an analyst, I would interview company management teams, consult with customers, competitors, suppliers, and other sources of knowledge in the industry to develop an unbiased investment opinion. I expect to approach this role with the same rigor, applying my training and professional expertise as a security analyst to identify the critical issues and relevant facts of each case and evaluate them relative to the zoning regulations. Please know that I'm aware of and committed to the many hours needed for preparation, study, and review of the cases for the weekly BZA public meetings. I moved to the District of Columbia in 2003 and currently reside in Ward 4's Crestwood neighborhood. I took up residence in DuPont Circle, initially took up residence in DuPont Circle, but have lived in the neighborhoods of Brookland and Bloomingdale as well. My family currently owns a small portfolio of missing middle housing type rental properties in wards 4, 5, and 7. And over the years, I've held interest in properties in 6 of the district 8 wards. Although I have done renovations to my personal property and provided financial support for development projects, I've never functioned as a developer, nor have I ever had direct dealings with BZA. As such, I approach this appointment with an open mind, without an agenda, and unbiased by past hurts or harm. I've witnessed the rapid growth that's taken place in the district since I've been here. I recognize the importance of the district zoning laws and regulations in sustaining viable residential and commercial neighborhoods. I've come to appreciate the BZA's role in promoting careful and healthy development, hearing requests for variances, special exemptions, and appeals from administrative orders. Through my research of previous public hearings, I have seen BZA review both large and small cases. I've observed matter-of-fact discussions, as well as some very emotionally charged testimonies from both applicants and community members. If confirmed, I will work diligently to quickly develop a practical understanding of the zoning regulations, consulting with the technical experts who serve on or support the board. I believe my perspective as a homeowner, a resident of the District of Columbia, an investor, a missing middle housing property owner, will enable me to empathize with both the applicants and community members as they appear before the BZA to present their concerns. I'm confident that my background and perspective have prepared me to be a fair, impartial, and effective member of the Board of Zoning Adjustment. I appreciate this opportunity and thank you for your consideration of my appointment. I'm available to answer any questions.
Thank you, Mr. Blake. Thank you for your interest in serving. How did the membership on the BZA come to your attention?
I have been looking for a way to add value to the city. And I wanted to do something that really added value and leverage my skill set, not simply be in a position for position's sake. I sent my credentials to MOTA and told them and explained to them that I would be interested in providing some type of service. They actually reached back to me and asked if I would be interested in being considered for this position. I did some research about the board's role, the type of things that the board was required to do, the commitment of time required. I felt that it fit my skill set, and it was a value-added position where I could make a difference. I went through the process, interviewed, met various people, and was honored to have the mayor nominate me.
Now, when you say fits your skill set, you have extensive skill in securities because you were a securities analyst for 25 years. You have extensive experience with property investment because that's what you do now. So what do you mean by it fits your skill set?
Sure. In doing my analysis and as a research analyst, there's a lot of work that goes into understanding details. So the biggest challenge in this job, in this role, is to understand the question that's being asked. The second issue is to truly understand the rules under which you will be applying those, answering that question. To go through the detail that we've gone through in looking at bond covenants, which are very technical in nature. I've also dealt with highly regulated industries such as insurance and banks. To understand those regulatory environments and the rules to apply are critically important. I don't underestimate the difficulty in that. I think that in the near term, I'll spend an enormous amount of time familiarizing myself with the zoning code, but I also recognize that there's some resources available to support that, and to learn the understanding, to get a better understanding of the zoning rules and regulations and ordinances. So the commitment on my part more so is to spend the time and effort to get up to speed on those zoning regulations and to find the information I need to make a prudent, logical, rational decision regarding those rules and how they apply, the conditions, how they apply to those rules.
Am I correct? A minute ago when I asked you that question, I said you have extensive experience with securities and you retired from that field. Is that a correct understanding?
Yes.
And am I correct in understanding that now your work is around property investment, investing in properties?
It's in property ownership, rental properties, and some investment in property, among other things.
You refer to it as middle, gosh, I have this written down somewhere, as missing middle housing. What is missing middle housing? It's a term.
Interesting concept. It's a development concept which basically looks at smaller townhouse, duplexes, small apartment buildings that actually are situated near corridors in the city, near transportation corridors, things of that sort, and typically are situated in residential areas. So smaller apartments, duplexes, things of that nature in small areas, in residential areas.
So it's not single family, it's apartment, multifamily?
It would not be a single family home, but it would be duplex, townhouse, small apartment building, quadplexes, things of that nature, and greater small apartment, yeah. Not including single family and not including large complexes. Garden apartments could be included in that definition, things of that nature.
So it's middle between single family and large apartments?
Yes.
That's what the middle is. I'm just taking a note here. Now, you live on Crittenden Street.
That's correct.
And I asked that because it came to my attention, so I have to ask this. For your residents, it doesn't appear that you're taking the homestead exemption, even though that's your property. Can you explain that?
Sure. There's a negligible savings involved in the Homestead Act from my perspective, and I've just not done it.
But one of your investment properties is 2113 First Street,
Hmm.
and that is taking the homestead.
Okay. I resided at 2113 First Street at one point, initially before I acquired the property on Crittenden Street. We then would have had that exemption, so it just has been applied there as opposed to at Crittenden.
Don't you think you should fix that?
I will.
But the First Street was your former residence. When did you move from there?
Be around 2006.
I may have written this, I may have sent this to you in my pre-hearing questions, and thank you for responding to them. Are you current in your taxes and obligations to the district and federal government?
I believe so, yes.
You said in your testimony that you are you're aware of the time commitment and that you can fulfill that time commitment. What is your understanding of the time commitment?
In general, in preparation for the cases, we receive the cases on Friday, and my understanding is it takes anywhere from 10 to 15 hours to prepare for each case, with the dockets being about anywhere from 5 to 15 cases, on average 10. I suspect, though, in the near term, it will take me significantly longer than that to review the cases because of I need to build my familiarity with the zoning rules and regulations. So it's going to take you actually a lot more time than that in the near term.
And how often does the board meet?
Once a week on Wednesday, 9:30.
So you have the 10 to 15 hours each week, plus the meeting itself, that you can commit. There was a question there.
Yes, I do have I'm willing to make the commitment. I don't underestimate the responsibility in this task. I am comfortable with it. I've discussed it with my family. We're committed to meeting the obligation, and I am committed to doing a good job in this role.
Now, I know I sent this in my pre-hearing questions, and I believe you spoke to it, but I will ask it again because I always do at hearings. Do you foresee that there are any possibilities of a conflict of interest? And if there is the appearance of a conflict of interest, what would you do?
In the event where there is a conflict of interest, that is, I would own property or something like that would come before the board. The first thing I do is I disclose the information, counsel's opinion, and likely recuse myself based on but my actions would be based on what the advice would be from the Attorney General's office.
Okay. In your pre-hearing questions, the answers, you indicated there's a company, Webster Commons, that you have some interest in, that it does business with the district. Could you describe that?
Sure, it's an apartment building and the series of apartment buildings, and the activity would be using the tenants that work through the voucher system.
How many apartments does Webster Commons?
16.
give me a second here. The Blue Water Group and Blake Properties does not directly do business with the government other than maybe that voucher program?
Blue Water is not associated with property ownership of any type. It's a consulting firm in the water industry. The Webster Collins is the only other property that would be involved with that, the government.
Okay. Did you say water? How did you get into water
Yes.
consulting?
Again, it goes back to my skill set. I have been involved in a variety of business ventures over the years. A dear friend of mine who has a tremendous amount of expertise in the water treatment industry has a consulting firm that goes through and provides consulting services for municipalities in terms of their water treatment processes and plans to maintain the investments, to keep them up to speed, to focus on criticality and making decisions about reinvestment. I've been involved with that from the financial analysis portion to help them recognize the financial benefits of these this approach to assessing value.
Okay.
And so I that's how I got involved.
Interesting. What is the difference between a variance and a special exception?
What's the difference between a variance and a special exception?
Yeah.
A variance tends to deal with a situation where a property has elements which are completely, or a use that the owner wants to have is completely in contrast or conflict with the zoning laws. Under that is a special test which the zoning BZA can give them relief, which reside, first of all, they have a tremendous burdens, it's a unique property, and that there's some type of hardship created by that circumstances with strict application and code. That's the first test that has the first two tests that have to be met. A third test is that it has to be consistent with the purpose and intent of the zoning regulations and not cause substantial harm. So that's a very significant test and a significant request. The second one, a special exception, is something that's use that's anticipated by the rules, but certain conditions need to be met in order to do the particular thing that they use for the property.
If somebody comes before the board and says, I have a trapezoidal shaped property, which is kind of unusual, it's not a rectangle, and says that I need to be able to expand the size of my house because I want to accommodate my my wife's in-laws, and that's a hardship. Would you agree that, as I described it, that sounds like a hardship and that it's a unique property?
I would agree that it might be a unique property, but as far as hardship's concerned, that would be more of an inconvenience, because the nature of the hardship has to relate to the nature of the hardship has to relate not to inconvenience but it has to be something related to the property. So if a family is bigger, you could buy a bigger boat, you got a bigger car, and you need to go. That's an inconvenience. It's not necessarily a hardship that's created by the property. That property you described may be problematic in terms of something. But if it's and this is all hypothetical, because there's a number of things that have to go into be considered to make any decision. But the nature of the property may, in fact, given its size and shape, may make it difficult. But that would be for, say, if you're trying to assume if it's something that's consistent with the zoning rules and regulations, you may look at, is it something that's been used for permitted use, which would be something like a home. Well, it is permitted for a home, and their home is being is in fact being used. It is a house, and there's a house there. So it's being used the way it could be used, and I would argue that request would be more of an inconvenience issue versus a true hardship. But again, there'd be other details and factors that would have to weigh into the decision beyond what we just talked about. But based on those parameters, that's what my thought would be, and how.
Well, I realized that my question was based on very skimpy detail, but it was to just get a sense of your knowledge in this area and what your attitude would be toward it. Let me tell you that I have pushed and pulled with the BZA over the years because I think that they're too quick to give approved variances. And I think it's a reason why their caseload is as large as it is. The theory behind a variance is that it is what maintains the constitutionality of the zoning regulations. If you think about it, the zoning regulations, if we say that you can only develop a property a certain way, it could have the effect, could theoretically have the effect of depriving somebody of the use of their property. So variance is that relief valve, so to speak. So I would say I don't agree with you on your answer regarding unique, because unique has to be something where the property is such that you really can't use it. I'm thinking of, I don't know if there was actually a variance here, but what comes to mind is if you go up North Capitol where it turns into Blair Road, and it may be up around, well, it's north of New Hampshire. There's this little triangle. They just built a house on it, but it was a little triangle. And my guess is it was a variance because you couldn't get the side yard and the rear yard as well as build a habitable house. I mean, the property just couldn't be used. And so that would be a unique condition. But over the years, I've seen properties where somebody comes in and says, well, there's a slope in the backyard. Okay, there's a slope. Does that mean the property can't be used? Or it's trapezoidal shaped. Okay, well, every property, if you think about it, like a snowflake is unique. They're not exactly identical, but does that, is it truly unique that it can't be developed? So I think that the three-pronged test to a variance, which you spoke of, is intended to be a fairly high bar to maintain the constitutionality of the zoning regulations, and that the zoning commission asks for, in the long run, it asks for more cases than there should be, because it's almost like, well, if I have the filing fee and I come in and I cry hard enough, the zoning commission will feel sympathy and agree that my property is unique and that my hardship is a hardship. And I think you were spot on when you said inconvenience does not equal hardship. Hardship has got to be where the case, the property, you can't use the property. That's the hardship. So I'm just saying that by way of, since you're looking to how do I want to put this? Explore this new experience. I figure there's some value in my sharing with you some of my view on this. And it is of concern, just as Mark.
Chairman Millicent, I would.
If I could just finish.
Chairman Millicent, I would want to say though.
It is of concern because of, for instance, the testimony from Commissioner Mark Eckenweiler before you testified, where there are abutting property owners who are affected. And so these standards have a real purpose. I'm sorry, what were you going to say?
I was going to say that actually in your analysis, I did not see that my answer was inconsistent with your assessment. Because the property was actually had a house on it and it was in use, it was being used. So it wasn't that it was not able to be used. So I felt comfortable that it wasn't being used. The question was, if it was an empty lot and you couldn't build at all to provide a use that was consistent with the zoning laws, I would then say that would be the not able to use, but it is being used. And it's being used for a purpose that's already seen in the zoning law. So it wasn't incompatible with what you said. Actually, and I may not have articulated it well, but what I said was not inconsistent with what you're saying. It's just the conditions you laid down had an existing structure in place. So that's why the way you explained it, and had you said it was an empty lot, I would have approached it the same way. And I do very much agree that it's important to take into consideration all the factors. In fact, the code requires that we take into consideration the implications of many special exceptions and variances for sure on the impact on the community. You're focused on, and the code requires that you look at the impact on the abutting and adjacent property owners. You heavily weight the impact, the input from the community. After all, they have to live with this, literally. So I have done carefully thought about that, and I want to just make sure you know that my thought pattern did already incorporate what you had said.
If you find that this is probably going to be very poorly phrased, my question, but if you find that the colleagues on the BZA are a bit soft on these issues, are you willing to speak truth to power?
Well, everyone on the BZA comes with a different perspective, right? So when I look at the perspective that you bring, you've got people with a legal background. You have people serving from the zoning commission who have a good understanding of the intent behind the zoning rules and regulations. You have people from the nation's the capital planning on there. There's a lot of input that comes in from various sources. I wouldn't argue that they're soft. Their position may be different than mine, and my view needs to be heard just as the people that present their views need to be heard. So long, I will base my decisions based on how it applies to statutes, and I will say my opinion publicly, which may or may not influence the others, and I'll listen to their opinion. I'm comfortable disagreeing, but I'm a very rational thinker, and I'm happy to explain why I have thought and made a decision the way I made it.
Have you, in your research, read some of the case law?
That's a good question. I have looked at some of the case law briefly. I have also observed several hearings and watched how the cases have been heard and the information that's come with it. I'm not an attorney, so I have to rely heavily on the direction from the Attorney General's office, the information from Office of Planning and the zoning staff to understand what each of these requirements is and how they could be met. But each situation is unique. So to the extent that I can't just simply say from precedence, this is it, it really is based on the evidence provided to assess each and every case to determine if it meets the criteria. So I have looked at some things. I've noticed that, frankly, from a zoning perspective, you've got to look at it's a totality and a way you should look at this. For example, decisions are the policies are set by the comprehensive plan. The zoning commission sets the standards that represent the land use policies. Now, to the extent that they're changed, and the BZA, of course, as we talked about, kind of balance the property rights versus the zoning ordinances to kind of create an environment where both can be objectives can be achieved. To the extent that there's things that take place that are inconsistent or whatever, or there's some bigger issues that all has to come down from the policy side, and those things can change day to day. And the zoning rules will have to change to reflect the changes in policy. And that would affect the actual rules that we have to apply. In no case would the role of the BZA change in terms of applying the rules that have been set by the governing body and the policies, but things change. And that's where we would have some of these conflicts.
Well, I do think that it's worth looking at some of the cases, the Court of Appeals decisions. I'm not a lawyer, but I always find that they can be informative as to better understanding what the law requires. I do not have any other questions for you. I wish that this hearing was in person and not virtual. It'd be nice to actually sit across the table from you. I want to thank you for your interest and your willingness to serve. Let me just ask if there is anything else you want to say before I adjourn this roundtable.
Certainly, Mr. Chairman. The one thing I want to say is, again, to reaffirm my commitment and my willingness to do the hard work involved to be an effective member on the board.
Thank you. Thank you. You have the last word. The record in this matter, as I indicated at the beginning, is open for 2 weeks. It will close at 5 p.m. on February 18th. That's for you, Mr. Blake, if you want to submit anything more, or anybody else who may be watching or is aware of this hearing. They have 2 weeks to file. Again, thank you. The time is 10:57 in the morning, and this hearing